Welcome to This Explainer. Today we are diving into something absolutely crucial for anyone doing business, practicing law, or studying legal frameworks. Think of this not just as a quick lesson, but as your ultimate preventative survival guide for crafting bulletproof commercial agreements in India. We're talking about Indian contract drafting basics. Whether you're a junior lawyer, a student, or a business professional, mastering this skill, well, it's basically like having a superpower in the commercial world. Let's get into it. Now, I have to ask, have you ever read a contract and felt like it was written to confuse you on purpose? Like it's just a giant puzzle? Don't worry, you are definitely not alone in that. It's a super common frustration when you're faced with a wall of heavy legalese. But here is the big secret. A genuinely good contract doesn't actually do that. It doesn't just create an agreement on paper. Its actual job is to prevent disputes before they even happen. Good drafting protects your rights and saves you massive amounts of time, money, and legal trouble down the road. So, let's establish exactly what we're talking about here. Contract drafting is essentially the legal translation of a business deal. It's the meticulous process of writing down the terms so that the rights, duties, obligations, and remedies of everyone involved are crystal clear. It is absolutely not some boring copy-paste clerical chore. Actually, scratch that, it is a highly strategic legal skill. When done right, it translates a friendly handshake into a legally binding reality, ensuring no one develops, sudden amnesia later on. Okay, let's dive into this perfectly structured roadmap we have set up for today. We'll start with why contract drafting matters, then look at the elements of valid contracts, the essential commercial contract clauses, the step-by-step drafting process, and we'll wrap up with common mistakes and tips. Starting right off with Section 1, why contract drafting matters. We need to completely shift our mindset here because a contract's real job is essentially preventative care for a business deal. A well-drafted contract accomplishes 4 core goals. First, it makes the deal legally enforceable. Second, it reduces risk. Third, it prevents confusion. And fourth, it provides a very clear roadmap if something goes wrong. When you draft effectively, you're directly impacting dispute prevention and ensuring that if push comes to shove, your agreement will absolutely hold up in court. Moving right along to Section 2, elements of valid contracts. Before you even write a single clause, you must understand the absolute non-negotiables under the Indian Contract Act 1872. Think of these like the vital organs of a patient. So, what are they? A valid contract in India generally requires a clear offer and acceptance, lawful consideration, competent parties, free consent, a lawful object, and certainty of terms. I need to be incredibly clear about this. If you are missing even a single one of these elements, the agreement may become completely void. The document you spent hours meticulously crafting? Literally worthless. Which brings us to a very real threat. Think about it. If the terms are vague, was there a clear agreement at all? The opposing side could easily argue there wasn't. This is exactly why, as a drafter, you have to constantly interrogate your own document. Who exactly are the parties? What is being promised? What's the consideration? What happens if someone defaults? And which law applies? If these answers aren't crystal clear on paper, they definitely aren't clear in the eyes of the law. Okay, Section 3, essential commercial contract clauses. If the valid elements we just talked about are the vital organs, these specific clauses are the agreement's immune system. They protect the transaction from external threats and internal misunderstandings. Now, what's really interesting about this slide is how we can logically divide these 9 essential clauses into operations and risk allocation. On the operational side, we've got your definitions, the scope of work so everyone knows exactly what's being done, payment terms, termination rules, and amendment rules to ensure changes are formal, not just sent over a quick WhatsApp message, right? Then, on the risk allocation side, we have confidentiality, indemnity, and limitation of liability to decide who pays if things go terribly wrong, dispute resolution like arbitration, and force majeure for events completely beyond anyone's control.
Listen, I really want you to burn this golden rule into your memory. If a clause matters commercially, it should be written clearly, not implied. This is absolutely crucial for ensuring your business terms are solidly backed by legal translation. Never assume something just goes without saying. Say it, write it down, make it undeniably clear.
That takes us to Section 4, the step-by-step drafting process. Let's look at the actual chronological roadmap of how to put pen to paper, from the initial handshake to the final stamped document.
Let's walk through this 6-step assembly line. Step 1, understand the transaction. Step 2, identify regulatory and stamping rules. Step 3, assess the risks. Step 4, draft precisely without jargon. Step 5, negotiate and revise. And finally, Step 6, execute, stamp, and register. I cannot stress enough how uniquely critical stamping and registration are for enforceability in India. Ignoring this step can entirely ruin an otherwise perfect contract. There are literally cases of multi-million-dollar deals stalling simply because someone tried to save a few rupees on stamp duty. Crazy, right?
And that brings us to our final part, Section 5, Common Mistakes and Tips. Let's focus on the common traps young drafters fall into and how to practice some preventative care. And this brilliantly illustrates the difference between an amateur mistake and strategic drafting. Amateurs rely on generic templates. They forget dispute resolution details, and they use vague phrases like reasonable time. Let me tell you, trying to objectively define reasonable time in an Indian court is a nightmare you want to avoid for sure. Strategic drafters, on the other hand, tailor clauses to the specific deal, define exact timelines, set clear arbitration rules, and prioritize easily understood language over fancy, confusing vocabulary.
To wrap this all together, here are 3 final rules for your toolkit. 1, write for the future. Always assume a judge will read this document one day. 2, draft for the worst-case scenario. And 3, keep it completely clear and specific. The best contract isn't the one with the most sophisticated vocabulary, it's the one that leaves 0 room for confusion.
So what does this all mean? It's summarized perfectly right here. Good drafting is not about assuming trust. It is about planning for disputes. Let that really sink in. When you master valid elements and precise risk allocation, drafting transforms from an intimidating chore into an incredibly powerful tool. So I'll leave you with this question. What potential dispute can you prevent today with a well-crafted clause? Thanks for joining me on this explainer. Use these tools to protect your deals and keep learning.